What informal documents challenge a will in probate? Have you ever wondered what kinds of papers or writings could cause a will to be questioned in court? When someone passes away, their last will and testament is supposed to show their final wishes. But sometimes, other documents or statements can raise doubts about whether that will is truly valid. These are called informal documents, and they can be very important in estate disputes. One common informal document is a handwritten note or letter from the person who died. If they wrote down a different plan for their estate or changed their mind, that note might be used as evidence. For example, if the decedent left a letter saying they wanted to leave their house to a friend instead of what the will states, that could challenge the will's validity. These notes do not follow formal rules for making a will, but they can still influence the court. Drafts of a will or amendments, called codicils, are also informal documents. Sometimes, people make changes on scratch paper or in drafts that were never officially signed or witnessed. If these drafts show a different intention than the final will, they might be used to question the will's authenticity. For instance, if a draft mentions a different beneficiary, the court may consider whether the decedent truly wanted that change. Witness statements or affidavits are another type of informal document. Family members or friends might tell the court that the decedent spoke about changing their estate plans or seemed mentally confused when signing the will. These verbal statements can support claims of lack of mental capacity or undue influence. They are not formal legal documents but can be very persuasive. Medical records or expert reports can also challenge a will. If a doctor's notes show the decedent was suffering from a mental illness or was under medication that affected their judgment, that information might be used to argue the person lacked the capacity to make a valid will. These records are informal but can be critical evidence. Sometimes, evidence of fraud, coercion, or forgery appears in documents or communications. For example, if someone pressured the decedent into signing the will or forged their signature, these issues can be proven with informal documents like emails, text messages, or handwriting analysis reports. Such evidence can lead to the will being invalidated. In probate court, these informal documents do not automatically override a properly signed and witnessed will. But they can be used to support a challenge if they show the decedent was not of sound mind, was coerced, or if the will was forged. Usually, the challenger needs to present clear evidence, which might include these informal writings, to persuade the court to change or invalidate the will. In estate planning, it's wise to gather all informal writings, witness statements, and medical records when planning or contesting an estate. Consulting with a probate attorney can help decide how best to use these documents. Remember, informal documents alone rarely prove a will is invalid, but they can be key pieces of evidence when combined with other facts. So, to sum up, informal documents that challenge a will include handwritten notes, drafts, witness statements, medical reports, and proof of fraud or coercion. They can be powerful tools in probate disputes, especially when someone believes the final will does not reflect the true wishes of the decedent.